Hello, my name is Kaisa Krusko and I am a family law attorney in Bedford, New Hampshire. This segment will focus on how to prove your petition to terminate parental rights. In order to be successful in terminating parental rights, you have to prove two things. First, you have to prove one of the grounds listed in RSA 170C5, and you also have to prove that it is in the best interest of the child. The grounds have to be proven beyond a reasonable doubt. However, the best interest of a child is not an evidentiary fact, and therefore that does not have to be proven beyond a reasonable doubt. There are 7 grounds on which you can rely to terminate parental rights. Those are set forth in the statute RSA 170C5. The 2 most common for a private petition to terminate parental rights, meaning a private party, not the state of New Hampshire, are the abandonment of a child and the failure to support. And those are the 2 that we will focus on later. For now, we will review the 7 grounds. So the first of which are the abandonment of the child and the failure to support. There is also the failure to correct conditions in an abuse or neglect case, meaning when a parent has had a finding of abuse or neglect and has failed to correct those conditions, DCYF, the state of New Hampshire, can petition to terminate the parental rights. There is also the ground of the mental deficiency or mental illness of a parent, the sexual, physical, emotional, or mental abuse of a child, when a parent is incarcerated for a felony and found pursuant to RSA 169C to have abused or neglected a child, and when a parent has been convicted of murder, manslaughter, conspiracy, attempt, or felony assault of a parent, sibling, or step-sibling of the child. In order to prove abandonment, there has to be a 6-month period of time where the parent has gone without either communicating with the child or without providing provisions for the child's care or support. The court should find abandonment when a parent's conduct has evidenced a settled purpose to forego all parental rights and responsibilities and duties to that child. The court must look at the totality of the circumstances, meaning that the court must look at all of the issues that are going on for the family. And one of the buzzwords that you'll often hear in termination of parental rights cases are whether the parent has shown only a mere flicker of interest. Meaning that the termination will not be barred if a parent has called once or twice or shown just a very minimal amount of interest in being a parent and exercising parental rights and responsibilities and fulfilling their obligations as a parent. In looking at the abandonment, the court will look at the specific facts of the case. Has a parent called? Has a parent tried to visit? Has a parent sent gifts or birthday cards, Christmas cards? Has a parent asked for information about the child's school, about the child's emotional well-being, about any medical issues that the child might have? And whether there would be any other things that the parent has done to show that there is a care and concern for the child. Some of those records might be phone calls, phone records, Facebook postings, other evidence that might show either that there was or was not any kind of communication or purpose to be a parent. If the 6-month period of time is shown, meaning that there has been 6 months without communication or provisions for care or support, the court does not necessarily have to find abandonment. Once the petitioner has proven that there has been a 6-month period, the parent defending against the parental rights termination can then rebut that 6 months period and show conduct either before the 6 months, during the 6 months, or after the 6 months period to show that there was a intent to be a parent. And some of that evidence might be taking a parenting course while incarcerated, might be sending letters, or might be an offer to pay child support even after that 6-month period of time has gone by. Two interesting recent cases from the New Hampshire Supreme Court would be very helpful to read to review what abandonment of a child means. And so those cases are In re Sophia Maria H. and In re Devin O. And you can find those on the Supreme Court of New Hampshire's website. The other ground, which is failure to support, means that a parent has substantially and continuously neglected to provide for a child's necessary subsistence, education, or care necessary for mental, emotional, or physical health, and had the financial ability to do so. If there hasn't been a child support order that the parent has been ordered to pay, then you might look to other things. Has the parent provided diapers, formula, food, clothing? Has the parent provided some sort of Christmas gifts or birthday gifts? Has the parent provided anything that could be used to help provide for the child? The statute itself is limited in what financially able means, and if you read the case that I mentioned earlier, In re Devin O., it discusses whether or not what it actually means to be financially able without actually coming to a conclusion. It may mean more than just being able-bodied and able to work. Certainly if there is a disability, that could be difficult to prove that a parent was financially able to provide support for the child. And other things that could be looked at for financially able: has the parent looked for a job? Has the parent submitted applications for a job? What kind of things has the parent done in order to be able to try to support the child? And so you want to look to the specific facts and evidence, and you have to prove that the parent was financially able to provide the support, and then failed to provide support. When the child goes to, or when the court goes to look at the best interest factors, those will also be fact-specific issues. And the court will look to different areas, such as what relationship, if any, has the parent had with the child, the reasons for the parent's absence, including the parent's conduct, such as incarceration, absenting the parent from the child's life based on the parent's own conduct, or whether the petitioner who is trying to terminate the parental rights has interfered in the parent's ability to have a relationship. And that could be, for example, if the parent has sent letters and the petitioner has refused to provide or disclose those letters to the child. If there have been telephone calls that have gone unanswered, if the phone number has been changed, if the parent or guardian of the child has moved and not provided a forwarding address, that could go towards the things for best interests. If the court finds that there are statutory grounds to terminate parental rights, the court will then examine whether it is in the best interest of the child. The court will take into account all of the circumstances of the family in considering whether it is in the best interest of the child. There is not a specific definition of best interests. However, the court will examine several different factors. One of those factors could be whether or not there is an adoptive parent ready to step into the role of a parent and provide financial and emotional support to the child. Some courts in New Hampshire may be reluctant to terminate parental rights when there is only going to be a single-parent household. That could depend on the reasons why the termination is sought in the first place. But that could be a factor that the court would consider. The court may also consider whether the parent whose rights might be terminated is able to support the child's current living situation, including the presence of a step-parent or the relationship between the child and the guardians, if the petitioners are not parents, for example, grandparents who have guardianship over the child. And that could be an important factor. If you look at the case of In re Sophia H., that was one of the factors that the court considered. The court found that the father in that case felt that the relationship between the child and the stepfather was positive, and he was looking to support that relationship. There are other Supreme Court cases where the Supreme Court has specifically said that the parent is not looking to disrupt the child's current situation, is only looking to visit and have a relationship with the child. So that will be a factor to be considered in the best interests. The court might also consider the relationship that the parent and the child have, whether or not there is a strong bond there between the parent and the child. For example, if the grounds weren't abandonment but were something like the commission of a felony, such as the murder or the assault or conspiracy or attempt for murder, in that kind of petition, the court might really examine whether or not, despite those crimes, the child has a good relationship with the parent. The court might also, when it is determining the best interests, look at the reasons for the parent's absence from the child's life. Did the parent commit a crime that voluntarily took him out of the child's life, or maybe not voluntarily, but it was the parent's own conduct that absented the parent from the child's life. Thank you for listening, and if you have any questions, please feel free to contact my office for further information.